You might be thinking, okay, I've been arrested for DUI. What does this process look like in court? Well, the very first thing is to get a lawyer. If this was any other type of traffic matter, then maybe the person can go to court and handle it themselves. But given the legal complexities and technical nuances of DUI, the very first thing is to hire a lawyer on the case. Once you get a lawyer, that lawyer can then begin gathering evidence. That's the first major step, aside from dealing with the driver's license if that's an issue. In gathering evidence, the attorney will use open records requests to get evidence from the police department. They'll use discovery motions to get evidence from the prosecutor. Once that attorney has the evidence in the case, that's when they can really evaluate the case, discuss it, review it with you, and then begin negotiating with the prosecutor, trying to persuade them to resolve the case to no DUI. And if they're willing to do that, wonderful. If they're not, then we're setting ourselves up for an important motion to suppress hearing. That's where we get to make our legal arguments to a judge about why certain evidence could not be used against you. It's critically important because even though we're the ones making the legal challenges, the prosecutor has the burden of proving to the judge why the police did not violate the law. As a result, they have to bring witnesses who testify and offer evidence. We then get to cross-examine those witnesses and make arguments to the judge. A very important part of our practice and why we're able to get even some of the most difficult cases on their faces resolved to no DUI. And if after all those efforts have been exhausted and they're still not willing to dismiss it or reduce it, then finally we're looking at the possibility of a jury trial.